Okay, Ms. Brumby, you're up.
Thank you, Your Honor. May it please the court. My name is Carissa Brumby, and I represent the appellate St. Joseph's Hospital on a writ of certiorari. I would respectfully request to reserve 5 minutes for rebuttal, Your Honor. Your Honors, this is a case where the appellees, through their attorneys, have repeatedly taken inconsistent positions in their pleadings. On one hand, seeking to have this action be deemed an ordinary negligence action and denying the defendant healthcare provider of its rights and protections under Chapter 766. But on the other hand, representing that this is a medical negligence action when it benefits them to obtain the very protections under the medical malpractice action with this defendant healthcare provider has been deprived of. The appellees not being bound by their prior admissions and the court denying the motion to dismiss premised upon the appellee's failure to comply with the mandatory conditions precedent of Chapter 766 is a departure from the essential requirements of law warranting review in this matter. Your Honor, this court's decision in Bove v. Naples, HMA, should guide this court's analysis of this action. As this court is aware, in Bove, the plaintiff's attorney served a notice of intent to initiate litigation against several healthcare providers, specifying in the notice of intent a date with which they contended that the statute of limitations commenced. Then, when the case proceeded into litigation, the defendant healthcare providers moved to dismiss because the plaintiff did not comply with the mandatory conditions precedent of Chapter 766 prior to the expiration of the statute of limitations. Upon returning into suit, the plaintiff tried to then argue a different and contrary date with which they contended that the statute of limitations would have expired, which was contrary to their pre-suit pleadings.
Let me ask you, in Bove, those were two different factual representations, and the court specifically said that those allegations were relied upon by the parties. And here we have, I think, two things that your side has relied on. The contract, the request to approve the contract. But that contract was not between the Wilsons and your side. And the other thing was the request for the extension of the extension of the statute of limitations, but they had already filed suit at that point. So I have trouble figuring out how you relied on those things to your detriment.
Yes, Your Honor. The court in Bove held that you can't take inconsistent positions with your pleading. The important factual representation in the contract and in the petition is the date with which they contend that the medical liability action arose. In the contract or the petition for approval of their fee contract, that date arose on March 5th of 2020. Then
you have not relied on those dates at all. Correct? I mean, there's nothing about them. First of all, the request to approve the contract and the request to extend the time really isn't directed to the defendant, basically. But I don't see any detrimental reliance on that when, in fact, the lawsuit is for pure negligence.
Your Honor, the plaintiffs in their complaint allege that Chapter 766 does not apply and that it is for pure negligence. However, in the petition to extend, they automatically—
But the petition to extend was filed after the complaint was filed, correct?
It was, Your Honor.
So one could argue that they couldn't, that they were not allowed to take that inconsistent position because they had already alleged that the chapter didn't apply.
Yes, Your Honor.
Okay. And in fact, the statute of limitations for med mal is half of the statute for pure negligence, is it not?
It is, Your Honor, but
so I don't see how your side was harmed at all by any reliance on that, or how you altered your litigation strategy or anything. There was just no allegation, no reliance.
Your Honor, I believe the dates and the facts within the petition were of such a nature that they were inconsistent with the complaint. For instance, in the petition to extend, they list that they're investigating a medical negligence action before, during, and after March 5th of 2020. That's the very date that they contained in their petition for fee approval. March 5th of 2020, importantly, was over a week after this patient passed away. It was after the autopsy, when the patient was at St. Joseph's Hospital. However, on one hand in the complaint, they want to allege that this infant was not a patient of St. Joseph's Hospital, was not entitled to Chapter 766. But on the other hand, they're alleging that all of the actions that occurred after this patient was deceased is being investigated for medical negligence. It's an action inconsistent with their complaint for them to, on one hand, automatically obtain benefits and protections from Chapter 766 themselves, but then in the complaint to turn around and tell the defendant hospital, healthcare provider, that they are not entitled.
The point is, Ms. Brumby, is that to file a lawsuit in pure negligence, which has a 4-year statute of limitations, and then to file a request for extension of a 2-year statute of limitations doesn't give them a benefit, does it?
Well, Your Honor, I think it does, and it was a strategy decision in this particular case. When the
I think they certainly were concerned that you were going to argue this was a med mal action, but that really isn't anything that you relied on. No, well, you're relying on it now, but I mean, it's not anything that would have altered your ability to characterize the action, as opposed to Bove, which was an inconsistent date of the allegation of an inconsistent date of the malpractice. Here, you're talking about inconsistent characterizations of the nature of the action, correct?
Your Honor, it is an inconsistent position. And I think when you're looking and doing a Chapter 766 analysis as to whether this is a Chapter 766 analysis, the court is allowed to consider extrinsic evidence to evaluate the petition or the appellee's position in this case.
Well, did you made this argument then to the judge below?
Yes, Your Honor.
And the judge maybe considered that and rejected it and said, hey, no, this is a negligence action.
Your Honor, the trial court did consider this to be a negligence action.
Correct. And that's consistent with case law.
Your Honor, we disagree that it's consistent with case law, especially when you get to the second portion of our arguments, which is the policies and procedures that are being critiqued in this particular case. But to go back to the petition for 1 second, in this particular case, the appellees did not need to require or to file a petition to extend the statute of limitations. But when they filed it, they had over a year left on the statute of limitations, even if the court disagreed with their interpretation of the case law. By them filing again and receiving the benefits and protections of Chapter 766, while they are then at the same time turning around to the defendant healthcare provider saying that they are not entitled to the protections of Chapter 766. That denied us of our benefits and protections of Chapter 766. But let me move on to the policy and procedure argument, Your Honor, in this particular case. Your Honor, in this case, the plaintiff's complaint specifically challenges the procedures and the safeguards that St. Joseph's Hospital had in place for its patients.
I don't actually see that specification in the complaint. I see a description of what, happened as best as they know. And they said, you failed to, keep track of this baby's body, et cetera. But it didn't say you violated your procedures, did it? It didn't say your procedures were incorrect. It didn't mention procedures, did it?
Yes, Your Honor, it does. In paragraph of the page 61 of the appendix, paragraph 11, it states that St. Joseph's Hospital did not have a procedure for bringing a body back to the morgue at the hospital. That paragraph in and of itself is suggesting that procedures at St. Joseph's Hospital are at issue in this particular.
Well, if this was a slip and fall and they alleged that St. Joseph's Hospital didn't have a procedure for how often you policed the floors in the hall, would that make this a med mal action? Because it would be a procedure in the hospital?
I think at that point, you have to look to Indian River Memorial Hospital versus Brown, Your Honor. That was a case where it was a slip and fall, which is ordinarily not considered medical negligence.
Right. And so in this case, the argument is there was no procedure for how you would track a body that, and by definition, pretty much, you're not at that point treating the body of a deceased.
Your Honor, it's also critiquing how St. Joseph's Hospital monitors its patients. And it's
not, I would submit that a deceased body is no longer a patient, but it alleges you weren't properly monitoring a deceased body.
And also, to follow up on what Judge Northcutt just said, isn't that basically the same argument that was raised in Shands that the Florida Supreme Court rejected in Towns?
Your Honor, in this particular case, the policies and procedures or the practices on how the hospital maintains the bodies of its patients, it's going to the very medical skill and judgment of the hospital administrators when they're implementing or deciding on those policies and procedures. That requires the standard of care from a qualified medical expert pursuant to statute 766-1027, who's qualified, who understands the non-clinical administrative issues with the hospital and can offer opinions regarding that. The appellee's argument is that common jurors would be able to understand all the nuances going into the policies and procedures at the hospital as to how it maintains its patients. They would have to have an understanding of the Agency for Healthcare Administration, the rules and regulations of the Department of Health, of the Joint Commission. These are nuances beyond the understanding of a common juror in this case. It requires a standard of care when the plaintiff now is critiquing the very practices at the hospital. It arises beyond.
Ms. Brumby, what medical expert testimony is necessary to establish that the baby's body shouldn't have been thrown out with the linens, which seems to be what the theory is? I don't understand. And again, going back to the Shands case, which was discussed in Towns, we disagree with the First District's analysis in Shands. While it's true that the hospital failed to confine the patient to her locked unit, the estate's claim arose out of the hospital employee leaving her badge and keys unattended where the patient could access them, not out of any act directly related to medical care or services that required the use of professional judgment or skill. Thus, contrary to the First District's conclusion, medical expert testimony on the professional standard of care would not be necessary for the estate to prove its negligence claims. How is that language not directly applicable here?
Your Honor, I believe in Shands and in Towns both. The reference of the pleadings contained in the opinion are purely directed at the act of the either employee or healthcare provider at that facility. It contains no reference to any allegations critiquing the very policies and procedures of hospital employees and when they should be have their keys, how they should not let the keys with the patient. With Towns particularly, they only could critique the at issue tact hold that is happening. They don't critique the policies and procedures or the practices that are set in place by the facilities administrators as to when or how tact hold should be implemented. I believe that's what brings this case, and that's what's different from Towns, and that's what brings it more in light and more in line with Indian River Memorial Hospital v. Brown, because it's not just the slip and fall in that case. It's when the plaintiffs formulated their complaint to critique the policies, procedures, and practices of the hospital, which changed it and morphed it into a different case. If you look at Bell v. Indian River Memorial Hospital, which the appellees rely heavily upon, and you look to footnote number 2 in that case, where the court describes the allegations are described as summarily, mom informed the hospital personnel that she wanted the remains of the infant returned to her. The infant's remains were not returned to her, and injury resulted from that. It's describing and alleging one specific act. In Indian River v. Bell, they don't then go into allegations of the hospital's policies and procedures regarding patients and the return of patients post-autopsy were woefully inadequate. If you look to the appellee's response to the appellant's motion to dismiss in this action, they make their intentions significantly clear as to the attack that they are going to implement in this particular case on the hospital's policies and procedures in this action.
Ms. Brumby, I want to follow up on what Judge Northcutt said there, because it was a question I had here too. Who is the patient? I mean, you have a former patient that was the mother. The father was never a patient. And then you have a deceased child that's a few days old. The statute speaks of a patient. So how do you get there?
Your Honor, we get there. In medical malpractice actions, stillbirth actions that the parents bring, although dad's never a patient, dad can claim pain and suffering after the stillbirth of a child who is deceased. So I don't necessarily think that it's the patient in and of itself being alive which disposes of this issue. Again, the hospital contends that how it maintains its patients in the hospital with the rendering.
The situation you described, that would be a med mal wrongful death case. We're not talking about a wrongful death here. We're talking about a failure to track a dead body.
Your Honor, I don't believe that the stillbirth would be a wrongful death. I believe it would be a medical malpractice with the pain and suffering of the parents. I don't believe it's categorized technically as a wrongful death.
Well, not in that sense, but it would be a wrongful death stemming from medical malpractice. That's not what the issue is here.
And to follow up, would your analysis change if it were someone other than the nurses who allegedly threw these sheets out? What if it were the cleaning staff or someone else? There's no medical personnel. Is your analysis still the same?
Your Honor, I believe it would be, for the fact that hospitals can be held liable in medical malpractice actions for the actions of their employees and healthcare providers. For instance,
So that's generally true of any employer if their employee is negligent, correct?
right, but they've been held liable even in instances where the active tortfeasor was not a healthcare provider. Again, the hospital's position that its care that it provides for deceased patients still falls under the realm of professional healthcare services. Your Honor, in this particular instance, implying from the plaintiff's complaint that there was a nurse that was following the hospital's policies and procedures on how to handle deceased patients when she went down to the morgue to grab a gurney, to return up to the oncology ward, to again follow her policies and procedures implemented by the hospital. If there's a mistake that occurs by a healthcare provider while they're following the framework with which the hospital administrators have set forth, we believe that constitutes professional healthcare services. And again, 766-1027 sets forth the experts that would be entitled to testify regarding the prevailing professional standard of care.
Judge Stargell and I took you into your rebuttal time, and I'll still give you 3 minutes if you want to save it.
Thank you, Your Honor.
Okay, Mr. Sprague.
Your Honor, Aaron Sprague on behalf of the respondent. This case is very simple. The question the court has to answer is whether the plaintiff's complaint sounds in ordinary negligence or medical malpractice. The analytical framework for answering this question is clearly laid out in the Florida Supreme Court's Towns decision, and the answer to this question is found in the 4th DCA's Bell case and in this court's decision in Lyles. And when this case is analyzed pursuant to Towns and in the light of Bell and Lyles, it's abundantly clear that the plaintiff's complaint sounds in ordinary negligence. And I'm going to use as my framework the analytical outline that is given in Towns and walk through the Towns factors and compare our case to those factors. And what we're going to find is that in 3 out of 4 of those factors, this case does not sound in medical malpractice. So in order to sound in medical malpractice, according to the Florida Supreme Court in Towns, the case has to arise out of medical diagnosis, care, or treatment that was provided to the claimant, and that's from this court's Lyles decision, by a provider of healthcare using professional judgment and skill. So let's first look and see if this case arises out of medical care, diagnosis, or treatment. Now, before I begin, I want to point out that the standard is whether it's medical diagnosis, care, or treatment, not whether they're engaged in professional duties, not whether they are engaged in professional healthcare services. That is a standard that the defense, with respect, has created out of whole cloth. What the Towns court said is that it has to arise out of medical diagnosis, care, or treatment. The question about whether this case, the instant case, arises out of medical diagnosis, care, or treatment is squarely answered in Bell. In Bell, just like in this case, there was the death of an infant. The infant was sent for autopsy. And then the infant's body, unfortunately, was lost by the hospital. And the court, in holding that that case sounded in ordinary negligence, held, and I quote, "The wrongful disposal of the deceased patient did not fall within the plain meaning of diagnosis, treatment, or care. The fact that the disposal of the child's remains took place in the hospital does not mean it constituted medical malpractice." And as Judge Northcutt observed, that simply makes sense because, unfortunately, at the time the events in the plaintiff's complaint took place, Jacob was unfortunately deceased. And he cannot, under Bell, be receiving medical care or treatment under any understood definition of that term. So the next, in as much as a case arises out of medical care or treatment, that case or that care has to be being delivered to the claimants. Care being delivered or given to somebody else doesn't count. In Lyles, this court's Lyles decision, the daughter, who was the plaintiff, brought suit for the disposal of her mother's tissues following the mother's death in the hospital. And this court held that that complaint did not sound in medical malpractice. And one of the reasons for holding that was that the daughter had never been a patient and had never received any medical care or treatment at the hands of the defendant. Similarly, in the Reeves case, which we cite in our papers, a home health care aide was injured when trying to assist one of her patients who was falling off a bed in an emergency room. And when the home health care aide brought suit against the hospital, the court held that that suit did not sound in medical malpractice, but rather in ordinary negligence because the home health care aide was not a patient and was not receiving any care or treatment. In this case, the father was never a patient of the hospital. The mother had been a patient for labor and delivery, but we're not bringing any claims related to labor or delivery. The complaint focuses on the disposal or loss of Jacob's body. And with those allegations, they do not relate to any sort of medical care, diagnosis, or treatment by the plaintiffs in this case. And it's important to note, factually also, Nurse Perez, when she goes down to the morgue, not only is she not providing any medical care or treatment to the plaintiffs in this case, she's not providing any medical care or treatment to anybody because she's retrieving a gurney for another deceased individual. So she's not providing care or treatment to anybody at that point. Moving on then to whether this case involves professional judgment or skill. Not everything done in a hospital, even by healthcare providers, involves professional judgment or skill. And you can look to the hot tea case, the Quintanilla case, or as your honors have observed, the Shands case, the Shands versus Lawson, where keys to a secure unit were left out. This court's decision in Lyles is dispositive of that issue. In Lyles, the court held that the disposal of human remains does not implicate medical professional judgment or skill. And in fact, in Bell, the court observed that the handling of human remains were, quote, ministerial. Another issue that's important when you look at this prong of the Towns analysis is the Dummigan case, which we cite. The Dummigan case holds that if you have negligence that's not unique to the medical setting, then it can hardly be said that it implicates medical decision-making. So in the state of Florida, funeral homes, funeral directors are sued all the time for the wrongful handling of medical or of human remains. And just because in this case, the wrongful handling of human remains is done in a hospital doesn't convert an ordinary negligence claim into a medical malpractice claim. So under 3 out of 4 of the criteria in Towns and its progeny, this case doesn't fit. This is an ordinary negligence case, not a medical malpractice case. Now the hospital has asked this court to ignore Towns, ignore Bell, ignore Lyles, ignore all of the decisions to the contrary and focus basically on 2 things. One is the argument that this case involves policies, and cases involving policies always sound in medical negligence, and that's simply not true. Certainly Towns doesn't hold that. If you look at the first paragraph of the Towns decision, the court lays out what it's going to address, and the court states that they're going to set forth the standards for how you determine whether something sounds in medical malpractice or ordinary negligence. And the court did not say in Towns, well, apply these factors unless there's policies implicated, and then that is an overriding consideration. And in fact, the argument that medical or a hospital's policies always implicate medical negligence is simply not supported by the case law. In Brown, Brown was not a slip and fall case. Brown was a case where a patient was on a gurney in an ER and fell from the gurney and was receiving treatment at the time they fell from the gurney. The other case that was cited by the hospital is Burns, and in Burns, an on-call doctor failed to respond to a call to treat a patient. So the policies in Brown and Burns directly implicate care of patients, right? And as Judge Northcutt again observed, there's all sorts of hospital policies, some of which may implicate medical care and some may not. Cleaning policies are a good example. And in this case, and the case law bears that out in Doe and Dummigan, which we cite, in both of those cases, policies were specifically pled, but they were held not to implicate patient care and not to raise claims of medical negligence. In this case, in as much as we challenge policies, they would be policies related to the handling and disposal of human remains. And as Bell and Lyles has held, that does not implicate patient care. So whether or not there are policies implicated in this case, they are not policies that go to medical care, and therefore this case would still sound in ordinary negligence. Finally, the estoppel argument that in other pleadings we have discussed medical negligence and that converts things into a medical malpractice case. First, I'd like to point out that there is no authority that they have cited under either the Florida Constitution's medical malpractice fee provisions or the automatic extension provisions of Chapter 766, which holds that if you invoke these things, that you have created an estoppel, that you are therefore bound permanently to medical negligence as a theory. They simply haven't cited any case law to that effect. Moreover, the cases which they cite, as your honors have observed, deal with specific factual representations that then cannot be disavowed. In both, they said the medical negligence occurred at time X, and then tried to come back and say, well, no, it really occurred at time Y. And the court said, you can't do that. In Griffin, when they are suing the underlying tortfeasor, they try to say, well, he's not within the course and scope of his employment. But when they try to collect from the employer in a subsequent collection action, they say, well, he was within the course and scope of his employment. And the court said, you can't do that either. Both of those are specific factual allegations. What we have done is simply acknowledged the fact that the courts may hold, and we hope this is not the case, and we argue against it, but the courts may hold that this is a medical negligence case. And we've pursued an alternative legal theory, which we are entitled to do in order to protect our clients. And that is in line with the Pius case and the other cases that we've cited in our papers. And when you look at this from a policy perspective, your honors, this is exactly what we want lawyers to do. We want lawyers to be proactive, to protect the rights of their clients. And it's important to note, and we heard this several times, that we've received the benefits of Chapter 766. Well, that's not entirely true. In fact, it's not true at all. Our position is this is an ordinary negligence case. And if the courts agree with us, then we never invoke the medical malpractice fee agreements or the automatic extension of the medical malpractice statute of limitations. We have not received a single benefit as of the time that the petition was filed or the court is hearing this argument. Also, along these lines, there's nothing impermissible about taking inconsistent legal positions when it comes to legal theories. And the Pius case makes that clear. And when the court considers the fact that it is very common practice in a wrongful death case where the cause of death is in doubt, for in the same complaint, a plaintiff to say, this event caused the death, therefore this is a wrongful death action. And in the very next count say that the event did not cause the cause of death, it was not the cause of death, therefore this is a survivor action. And there's nothing different than what we have done here. We allege and maintain that this is an ordinary negligence action, but we have taken steps under an alternative legal theory to protect our client out of an abundance of caution. And unless the court has additional questions for me, I am concluded.
Thank you, Mr. Sprague. Okay, Ms. Brumby, 3 minutes to rebut.
Yes, Your Honor. In response to the petition for extension being simply an alternative theory, the appellants disagree with that interpretation. This was not an attempt to plead an alternative theory. In the case that the appellees cited, Reeves v. North Broward Hospital District, that is in fact an example of how to plead an alternative theory when you're concerned about your medical malpractice action not being preserved with the statute of limitations. In that particular case, the plaintiff alleged a count for ordinary negligence, and in the alternative, pleaded a separate count for medical negligence. In that separate count for medical negligence, the attorney pleaded that they had complied with the mandatory conditions precedent of 766. If you look to the appellee's amended complaint in this action, they specifically deny the application of Chapter 766. They then filed their petition for extension of the statute of limitations, which was prior to needing to file any type of protective measure for their clients. And the distinction is it's not that they'll use it if they need it, Your Honor. They automatically get that protection from Chapter 766 when they file it. The whole time while arguing that the defendant healthcare provider isn't entitled to those same protections under Chapter 766. Your Honor, again, the appellant would ask that the court look to Indian River Memorial v. Brown. Again, the court focuses on the fact in that decision that this case normally would fall in a gray area where it would likely be considered ordinary negligence. But when they attacked the policies, procedures, and practices of the hospital, that brought it within the realm of Chapter 766, rather than just being in the gray area or being an ordinary negligence case, Your Honor. In this particular action, the appellees have specifically targeted the policies and procedures of the hospital. It's evident when you look at their response and all of the attachments that the appellees themselves filed in response to the motion to dismiss for the court's consideration. As they're challenging the professional skills and decision makers or decision making by experienced hospital administrators and healthcare providers in formulating the practices with which patients are to be maintained. We believe this implicates the prevailing professional standard of care, Your Honor, which would be defined or an expert would have to attest to by 766-1027. If this case is allowed to proceed forward with ordinary negligence, it's going to cause immense harm to the appellant because the appellees themselves would not have any strict requirements as to who is going to critique the policies, practices, and procedures of the hospital and how they maintain their patients.
And Ms. Brumby, your time is up.
Thank you, Your Honor.
Thank you both. In order to leave our virtual courtroom, you need to click the leave button